still Donnie, and welcome to Call to Reset. Happy spring, new digs, new recording digs. It's actually my office. My wife says it's got the best light, so we'll see how this goes. Anyway, hats off in the house. Welcome to episode number 5, Legal Fiction. I wanted to post this on the first day of spring, which was on the 20th. But as far as I'm concerned, it's today, around here anyway. On 3/20/21, our daffodils, tulips, and our crocus, or crocuses, or croci, were all starting to come up. But as of this morning, only the crocuses were in bloom, making them the first flowers of our spring here. Today again is March 22nd, 2021, episode 5, Legal Fiction. Well, let's recap from the last episode and where we are today. Last time in episode 4, we looked at the law of emergency. It is the number 2 of things we need to know and understand. This, along with the other, in times of war, law is silent, number 2, and the acts of President Abraham Lincoln between 1860 and 1863 form a mathematical axiom, something accepted as true, that things equal to the same things are equal to each other. But in the law of emergency, I'm going to quote this, I'll read it. This was from the Senate Report, 93rd Congress, November 19, 1973. A majority of the people of the United States have lived all their lives under emergency rule. For 40 years, it's now actually 88, freedoms and government procedures guaranteed by the Constitution have, in varying degrees, been abridged by laws brought into force by states of national emergency. From at least the Civil War, in important ways shaped the present phenomenon of a permanent state of national emergency. Senate Report, 93rd Congress. So everything so far, beginning with our Constitution of 1789, extraordinary occasions, the public safety requirement, setting the states into districts, the Lieber Code, the rules of engagement and occupation of one country into another. In times of war, the law is silent. Some state of national emergency by law became permanent. And these all form a mathematical axiom, accepted as true. Things equal to the same things are equal to each other. Today, number 3, legal fiction. Well, what is legal fiction? It is a thing, and it is a legal term. It has been around since ancient times, primarily sourced from the Roman Empire. In my book, Reset, Non-Alien's Guide to Resetting Our Republic, right here. For more information, you can see resetbook.com. I not only included legal fiction in the terminology or definitions, but it also had its own chapter called Legal Fictions. Well, prior to the publication in 2012, I spent years of research for the content of this book, 2009 to 2012. I had several people whose opinions and expertise I valued and trusted for feedback. And what I discovered, I shared. Well, one of these people happened to be a Supreme Court judge for the 7th District in the state of New York. He was a neighbor, and I frequently sought him out for his legal point of view. Surprising to me then, he had never heard of legal fiction. He asked his son, also an attorney, if he had ever heard of legal fiction. His son returned with the exact same quote from my book. Quote, "In the common law tradition, legal fictions are suppositions of fact taken to be true by the courts of law, but which are not necessarily true. They typically are used to evade archaic rules of procedures or to extend the jurisdiction authority of the courts in ways that were considered useful but not strictly authorized by the old rule. Legal fictions were used by courts prior to the existence of handling offenses. In a situation where one person sells stolen property to another person, legal fiction has been used to declare that, as the first person did not have the power to sell the property to the second person in possession of stolen property was considered to have also stolen the property and was therefore guilty of theft. Black's Law Dictionary, 804, 5th edition, 1979. Despite the fact that the judge had never heard of the term legal fiction, he understood how it was used in the legal profession. Well, how was this term used in ancient Rome, in the Roman Empire? In understanding this, we understand how it is still being used today, and you, in particular, may have actually benefited from it, or maybe you still will sometime in the future. Remember Julius Caesar? He was a descendant of someone from his family named Caesar, that was his last name, the family name, that supposedly was born a half-god. You know, where one of the gods has a relationship with a mortal woman and produce a child together. This child was not born naturally. It had to be literally cut out of its mother, which is where the words cesarean or C-section come from, to deliver a baby for the life of both the mother and child, if possible, when there is no other way. Well, Julius Caesar, actually his name was Gaius Julius Caesar, became dictator of Rome. He had one child that died in her life, later in her life. Her name was Julia, and many believe he had a son with Cleopatra, the Queen of Egypt. But for whatever reason, he had no immediate, acceptable, or legal biological offspring, which is usually the firstborn son, as an heir. So he chose his grandnephew. It's a good thing he did, because we recently just left the Ides of March the 15th, which is when he was assassinated in 44 BC. Oh, and one of the conspirators that killed him, he was going to be the second heir in the event that the first heir could not fulfill, if he died before the will was executed. Well, this second choice of Caesar, also one of those that conspired to kill him, in short, was named Brutus. True or not, as William Shakespeare said, Julius Caesar's last words in Latin, et tu, Brute, or you too, Brutus? Why was Julius Caesar killed? One big reason was that he proposed to the Senate that he be made dictator for life. I guess that didn't sound too good to them. But after the death of Julius Caesar, the Senate deified him, making him a god. His grandnephew, heir to the throne, inherited his name, title, and wealth. His grandnephew, Gaius Octavius, became sole heir at age 18, hence the name Octavian. After the deification of Gaius Julius Caesar, Octavian, as the son of Caesar, assumed the title of Diva Filius, Latin for the son of the divine. His full name became Gaius Octavius Julius Caesar Diva Filius, son of the divine. I guess they loved long names back in those days. Historians just called him Octavian, so as not to confuse him with another ancestor, also named Octavius. Oh, but he also had a regal name as the Emperor of Rome, Imperator Caesar Diva Filius, son of the divine Augustus, or simply Augustus Caesar. Well, this Caesar would have reigned during the times of the birth of Jesus Christ. His successor was Tiberius. Caesar Augustus was his stepfather. Tiberius, the second emperor of Rome, reigned during the crucifixion of Jesus Christ and the rise of his followers of the way that later were just called Christians. What is interesting about this fact is that the first two emperors of Rome were often just referred to as Caesar, as well as many that followed. Both of the first two were not the immediate and biological children of their fathers. They were all adopted. But still, with these adoptions, they inherited the names, titles, divinity, godness, power, and wealth, as if they were the true children biologically of their fathers. Sometimes people were chosen by Caesar to act in his stead and with all the authority of Rome and of Caesar as if they were Caesar himself. They were called in Latin legates. We also derive the words legacy and legal from those times. Today, legal fiction still applies when it comes to adoption, as if the adopted children were or are the biological child or children of those adopting them. How else is legal fiction used? Have you ever seen a Western movie? Or have you toured a Western movie lot? The camera sees what our eyes see, but it and us may not see everything. We may not see much of it. It's just movie magic. Sometimes it's a facade. It's fake. Let me show you a picture. Try to get this without too much glare. This is a picture of a Western lot. And you see the side. There's another front over here. But in the back, it's just held up with 2x4. It's fake. And you know, maybe they walked through the windows or they shot through the windows. There's a little ramps up here. Maybe they went through the front of the bar. But maybe the actual saloon was filmed somewhere else. But it looks like the real thing. So that's an example of legal fiction. It looks real, but it's not. According to Black's Law Dictionary, 804, 5th edition, 1979, the legal fiction, or the term legal fiction, is not used in a pejorative way in spite of the negative connotation of the phrase and has been characterized as scaffolding around a building under construction. Well, that's interesting. In 2012, to illustrate legal fiction, I found a picture of a scaled model of the U.S. Capitol. I blacked out the background, or you would see real people walking around this very large scale model, and they would look like giants compared to the model. So I blacked them out, and then I put scaffolding around it. And then there was another building of the Capitol as if it was being built over another one. So under the cover of darkness and behind the scaffolding, it would look like the Capitol was just being repaired, when now in actuality, it was as if another building in exact detail was being constructed over it. In the center is a throne. Our government had basically been taken over as if by a tyrant, an emperor, some ruler, some royalty, because of its laws, but it looked exactly the same. This is legal fiction. Now here's the picture that I did in 2012 to illustrate it. I don't know if you can see it really well, but there's the model. It's lit up at dark. Behind it there in the back is another dome. It's actually being built over the original. and it looks all the same. But anyway, in the show notes, maybe you'll be able to see a better picture of it. Well, in 2013, interestingly enough, our actual Capitol was in dire need of repair and much reconstruction. Pictures, scans, engineers were all working and documenting all the damaged areas. Some of it had to be replaced. It was beyond salvage. This was a structure that was mostly made out of wrought iron and painted white to look like it's sculpted marble or stone. And even during the times of the Civil War, there was work being done on. They couldn't afford to have a lot of people there, but there were 10 people working on the Capitol during the Civil War, and they worked from sun up to sundown. And they got a lot done, but still, they couldn't have any more than about 10 people working on the project. So from 2013 to 2016, the work actually began. And someone complained about it, talked about, it was costing too much. They were running into problems. There were overruns and under budget and not going to have it done on time. And so I think it really made them mad and pushed them even harder, because generally government does not get things done on time and on budget. But it got done on time and on budget and in time for the inauguration of the president, January the 20th, 2017. And here's a picture of the actual Capitol when it was surrounded by 52 miles of scaffolding. And it took about 1,200 gallons of paint to paint it. And there was, I don't know if you can see this or not. You will be able to see it in the picture. But in the center right up here, there's two people standing. I mean, they had scaffolding all around the statue on top of the dome. And there's two people just standing right in here. So you can see it for scale as to the size of it. This thing is huge. Well, they also did the interior too, because over the years, the rust had gotten damaged. Seals were broken. Rust was piling up in the gutter system. Water overflowed, got into the interior, started cracking inside. Paintings were damaged. So they did a lot of work to repair this. And, had they not done it, we might not have the Capitol today. But it was about a $60 million project. Well, like I said, in the show notes or the transcript, I will give you some links that you can look up to see videos and pictures. And it's a very, very interesting and a fascinating work that they did. And it's very valuable. I found it very valuable, and hopefully you will too. Well, continuing on, once upon a time in the United States, there was a young man that came with his parents to the U.S. from France. We owe much to the French. They helped us win our freedom from England, Great Britain. Many French soldiers fought independently or alongside our continental soldiers, and their navy blocked the British from escaping, forcing them to surrender at Yorktown. And the French, of course, gave us the Statue of Liberty. Well, this young man came with his mother and father to America. His father died, and his mother went back to France. John stayed, and by the time he was 21, he became a U.S. citizen. He wanted to become a lawyer and studied and became one. Then he started something entirely new. He wrote a first time ever special legal dictionary. It was unique in the entire world as it was based solely on our laws and our Constitution. Well, John settled in the Philadelphia area until his death. He published 3 editions of his law dictionary in 12 years. The first in 1839. He was preparing a 4th at the time of his death in 1851. The sixth edition was revised and published in 1856. Other well-known legal scholars contributed to its several revisions. By the year 1886, there had been 15 editions. His legal dictionary was known and often referenced during the so-called American Civil War. Abraham Lincoln knew of his work. The attorney for Mary Surratt referenced his work by his last name in his arguments and closing argument defending his client on trial. By the way, I suppose John was a popular name. 3 others with the same last name were all related and had the same first name of John. One of them also settled in Philadelphia. His son, the second, settled in New York, as did his son, John III. Guess who John III was the father to? Jacqueline Bouvier. Do you remember her? She married and later became First Lady to the President of the United States, John F. Kennedy. Jackie, as her father called her, because his name was Jack Black, because of his dark skin and dark hair. I guess he had a tan. Bouvier III. Well, anyway, Jackie was instrumental in developing the position of curator of the White House because there wasn't one before her. There had never been. Presidents would come and go, and they'd often leave their office, taking furniture and all kinds of stuff out of the White House. Well, Jackie petitioned the Congress to write a law preventing this from happening ever again. And they did. The legislation was written, it was passed by both houses, and it was signed into law. First Lady Jacqueline, or Jackie Bouvier Kennedy, remodeled the White House. She used her position and government funding to buy actual pieces taken from the White House from private collections, or she contracted furniture makers and specialists to make exact replicas from old photographs or from literature describing the pieces, color schemes, paintings, furniture, plates, silverware, even curtains. Was any of her family related to John Bouvier that wrote the legal dictionary? I do not know. But it is a French name, and the ancestors all came from France. Well, back to the other Frenchman, the other John Bouvier, who wrote the legal dictionary and about legal fiction. The following maxim, which is a short, pithy statement expressing a general truth or rule of conduct, appears in his dictionary as it compares to legal fiction. Fictions arise from the law and not the law from fictions. Unknown origin. Also, quote, fiction of law, legal fiction, the assumption that a certain thing is true and which gives to a person or thing a quality which is not natural to it, and establishes consequently a certain disposition which, without the fiction, would be repugnant to reason and to truth. It is an order of things which does not exist, but which the law prescribes or authorizes. It differs from presumption because it establishes as true something which is false, whereas presumption, like presumption of innocence, supplies the proof of something true. That's excerpts from Bouvier's dictionary. Let's take a look at the opening of this 6th edition and some of its preference. A law dictionary adapted to the Constitution and laws of the United States of America and of the several states of the American Union, with reference to the civil and other systems of foreign law, by John Bouvier, 6th edition, revised, improved, and greatly enlarged, Volume 1 and 2, 1856. Advertisement to the 4th edition. Quote, since the publication of the last edition of this work, its author, sincerely devoted to the advancement of his profession, has given to the world his Institutes of American Law in 4 volumes. Always endeavoring to render his dictionary as perfect as possible, he was constantly revising it, and whenever he met with an article which he had omitted, he immediately prepared it for a new edition. After the completion of his Institutes in September last, laboring too severely, he fell a victim to his zeal and died of the 18th of November, 1851, at the age of 64. Excerpts from the opening of John Bouvier's Legal Dictionary, 6th edition. Also a quote from the same. Fictions of law, the assumption that a certain thing is true, which gives to a person a thing, a quality, which is not natural to it, and establishes consequently a certain disposition, which, without the fiction, would be repugnant to reason and to truth. It is an order of things which does not exist, because it establishes a true something which is false, whereas presumption supplies the proof of something new. My paper's sticking my fingers. Shouldn't lick your fingers. I think there's something over here. Yep. I need tacky finger. Number 2, the law never feigns what is impossible. Then there's some Latin words for that. Fiction is like art. It imitates nature, but never disfigures it. It aids truth, but it ought never to destroy it. It may well suppose that what was possible, but which is not, exists, but it will never feign that what was possible actually is. Number 3, fictions were invented by the Roman praetors, who, not possessing the power to abrogate the law, were nevertheless willing to derogate from it. Under the pretense of doing equity, fiction is the resource of weakness, which, in order to obtain its object, assumes as a fact what is known to be contrary to truth. When the legislator desires to accomplish his object, he need not feign, he commands. Fictions of law owe their origin to the legislative usurpations of the bench. Praetor is a Roman magistrate responsible for the administration of justice. The word praetor is Latin for the man who goes before the others. If this is taken literally, the title may be derived from the army if we allow for a figure of speech. It may have been coined to describe a civil official. The word was certainly used to describe the first consuls. Number 4, it is said. Now this is very important. Every fiction must be framed according to the rules of law, and that every legal fiction must have equity for its object. To prevent their evil effects, they are not allowed to be carried further than the reasons which introduce them necessarily require. All of that was excerpt from Bouvier's Law Dictionary, 6th edition, 1856. The law abounds in fiction. There is an estate in abeyance, the doctrine of remitter, by which a party who has been desist of its freehold and afterwards acquires a defective title is remitted to his former good title. That one thing done today is considered as done at a preceding time by the doctrine of relation, that because one thing is proved, another shall be presumed to be true, which is the case in all presumptions, that the heir, executor, or executor, and administrator stand by representation in the place of the deceased are all fictions of law. Our solemn process upon dispossession, our casually losing and finding a ship which never was in Europe, in the para of St. Mary le Bow, in the ward of Cheap, are trying the validity of a will by an imaginary wager of £5, are imagining and compassing the king's death by giving information which may defeat an attack upon an enemy settlement in the antipodes, are charged of picking a pocket or forging a bill with force and arms, of neglecting to repair a bridge against the peace of our Lord the King, his crown and dignity, are circumstances which, looked at by themselves, would convey an impression of no very favorable nature with respect to the wisdom of our jurisprudence, breaks these fictions as absurd and useless. In a nutshell, legal fiction is legal because it proceeds from the law, but it is also fiction because it does not really exist. Where it did or does, it was and is supposed to be limited. And just like everything else we've looked at, legal fiction is a part of that mathematical axiom that things equal to the same things are equal to each other. There's just one final part of the four things we need to know and understand, and the next time we will discover government de facto. Have a pleasant spring day. I bid you adieu until next time.